Is this thing on? Welcome to the court gallery. Ladies and gentlemen, welcome to Lone Wolf's Court Gallery. What is going on? I have things all messed up on the screen right now. Excuse me while I fix these things, if I can. There we go. Ladies and gentlemen, we got a big night ahead of us. We got Judge McNally starting things off in only a way that Judge Dad can. And then we're very quickly going to move our way into Planet Washington for Anti-Harassment Calendar Monday, as we always do. And then we're going to check in with Judge Middleton for a couple of very interesting cases. And ladies and gentlemen, you know how it starts. It all starts right now.
Azim versus Feldman Dodge Jeep Chrysler. 2504578. Okay, gentlemen. Your name, sir?
Muhammad Ali Azim.
And your name, sir?
My name is Jason Coulter, representing Felon Automotive.
Okay. Can you spell your last name for me?
Coulter.
I got to make sure I understand this claim here. Just give me 1 second here. It's in small claims. Total amount is $1,750. It says 1988 Buick Regal. Driver side damaged.
Rear.
What's that?
Rear.
You said?
It's in the rear.
Okay.
The driver rear.
All right. Need. I can't read this, sir. Need frame body pulled out. He did not do before painting. Stumped in the back and my tail light. I can't. You're gonna have to tell me what the claim is about.
I will.
Okay. Tell me very briefly what the claim is for.
The claim is for, I went to an auto glass guy.
I don't want you to make it long, sir. Just tell me what you're trying to tell me and the reasons for the claim.
I took the car to him. I told him the rear ass have to be pulled on the frame, have to be pulled back and pulled up to get that ding out. So, because I have a light bar, one piece light bar that fits, have to be square. If it's not square, if you over tighten it, which he did, and he grabbed my tail light, and because he never pulled it. And when I.
All right.
Okay.
You two want to go out in the hall and talk. about this, or do you want to just proceed?
This was not in the Feldman Group itself. This is a gentleman that he works for me. There's no RO and authorizations between him and the guy that fixes his car. The guy works for the dealership, but nothing was done with the company at all. So his claim against Feldman is irrelevant because there's no paperwork, no sign of notification, no documentation, nothing. It's a side job that went south, basically. So he's suing Feldman even though the guy did it on the side.
Well,
So the case is being dismissed.
all right, slow down. I have to tell you before we go in this, before we proceed. By proceeding in the small claims division, you're both giving up certain rights. You don't have to proceed in the small claims division. If you proceed in the small claims division, both of you are giving up your right to a jury. Both of you are giving up your right to be represented by a lawyer. Both of you are giving up your right to appeal my decision. Plaintiff is giving up the right to seek in excess of $7,000. If you want to preserve any one or more of those rights, you just tell me. I'll listen. Don't interrupt me. If you want to preserve any one or more of those rights, just tell me. I'll remove the case to the General Civil Division, in which case you can hire a lawyer. You can appeal my decision if you don't like it. You can demand a trial by jury. And to the extent that you're entitled to it, plaintiff can seek in excess of $7,000. Do you understand everything I've said, Mr. Hazimi?
It was only $1,750.
I know.
Okay. Yes, I do.
Do you understand everything I said?
Do.
Do you wish to give up those rights and proceed here, or to have the case removed to the General Civil Division?
No, I have to proceed here.
You waive those rights?
Yes.
All right. Raise your both of you, raise your right hands. Solemnly swear affirmative penalties of perjury that the testimony you give in these proceedings will be the whole true self you got. Mr. Hazimi?
I do.
I do.
Mr. Coulter?
I do.
And what is your position there at Feldman?
Collision director with the corporate team.
Did you take the car into Feldman?
Yes, sir. And it was done at the deal.
Slow down.
Yes.
I thought you said he didn't take the car into Feldman.
There's nothing, no documentation that was ever there. No proof, no paperwork, nothing.
What? You took the car into Feldman. Did they give you some kind of a written estimate or hang on, or a description as to the type of work that needed to be performed?
Description by word. I told him what I want done. He said, I'll do it. The reason why I took it over there, Your Honor, because it was at the dealer. They had the down draft booth. It was a team, him and his wife. And I got to know him. He said, okay, brother, I'll take care of you, whatever you want. And he told me.
Who's he? Let's talk about who he is. Who is he?
That's Joe.
Joe who?
He goes by Joe or Joseph. His name is Joseph.
Do you know his last name?
No,
Why didn't you sue him?
because he was at the dealer and he won't even give me the time of the day when I was calling.
Who's Joseph? Do you know?
He was employed.
Where's Joseph?
He was unable to appear this morning
Where what?
because of the suit is not against Feldman, it's against Joseph directly. Not
I want Joseph here. They didn't give you any paperwork?
He didn't give me, he said, once you get the job done, then I will give you a bill. When the job was done, I told him my vision is not too good. And I didn't see the light was cracked until I washed the car. Then I didn't see the lights. I took pictures of them.
Did you pay this Joseph
Yes, I paid him in cash.
at Feldman?
Yes. And he took it. And I gave him $150 bonus. He said, thank you. Now I could buy a Christmas present. Easter present for my son. I appreciate you, brother. Thank you.
What is going on here? Hang on a second. Slow down. What's Joseph's last name?
Parker.
Maybe you need to sue Joseph Parker too. Do you see what he's telling me?
Yes.
Hang on.
I did not know.
Hang on. Hang on.
I'm sorry.
Stop. Time out.
I'm sorry.
Who goes into a dealership and pays cash and walks out with no paperwork? It doesn't make any sense to me.
No, he did it at the dealer, and he said, I will give you a receipt once everything is done.
You need to add Mr. Parker as a defendant here. And then we'll get to the bottom of this, okay? You can file an amended affidavit. Have that served on Mr. Parker too. It will remain Feldman and Parker. You can add Joseph Parker as a party defendant. Either way, Joseph's coming in here. Okay? Sounds like he was trying to make money on the side.
Yeah.
Well, the problem is you got, I don't know if he held out as that he was doing this for Feldman or not. And certainly he had the right to assume that he was. If he goes there, the guy's got Feldman clothes on. Well, that doesn't mean that Feldman's off the hook here, is what I'm trying to tell you nicely. Here's what you're going to do. Listen very carefully. You're going to file an amended affidavit and claim.
Is that me?
I'm sorry?
I have to file?
You want to bring in this other guy as a
Okay.
defendant. If he's trying to tell me that this guy was doing it on his own.
He did it in the deal.
I'm just trying to tell you what I would do if I was you.
Okay, I didn't know you were talking to me. I'm sorry.
Yeah. No problem. You want to file an amended complaint, affidavit and claim. Couldn't be here. I have a feeling he doesn't want to be here.
He will come in an heartbeat, but when it was addressed to Feldman, and he doesn't represent Feldman, I do. So
Well, he's the one with knowledge of the facts and circumstances of the case.
he is, you're right. You're
I
right.
know I am.
He has no problem coming in. It won't be an issue at all.
Maybe in the meantime. So you're going to add Joseph Parker as a party defendant. So your claim is going to be against Feldman, Dodge, Jeep, Chrysler, and Joseph Parker. Okay? And then I'll get to the bottom of this.
He made a
Judge,
All right.
he's going to
What?
have to have Mr. Parker served, so he'll need an address.
Right. Well, you can serve him you can get him served over at Feldman. You can have him served at Feldman. I mean, that's fine. It's not like a courthouse. So let's just set a new date. And maybe in the meantime, Mr. Parker and him can talk, and maybe they can resolve it. I'm gonna give you a new date. Just wait. I think we need to go to like the 3rd or 4th week of January.
We could do the 13th, Your Honor, but the 27th, we have a full day trial.
What about the 20th? Am I here?
That's probation. But if you want to,
Yeah, I want to make sure he gets this filed, served. I mean, we can try January 13th. At what time? 8:30? Or you want another time?
I guess let's do 10 o'clock.
I'm surprised he's still working at Feldman.
Trying to get the bottom of myself and do it with policy and transfer to the EPS.
If you get to take cash and don't turn it over to your employer, well, I got, January 13th, you go down the hall. You're gonna fill out amended affidavit. You're gonna add Joseph Parker.
Could you write it down for me, please?
Jennifer, Parker. You know what I'm telling him to do, right? Obviously. So just
Yes.
have him fill that out, and then you have to have Mr. Parker served. Okay?
Can I say something, please?
Yeah, as long as we're not going to talk about the merits, because we're not resolving
Okay.
this today.
Mr. Parker, when I went to him to tell him, why'd you crack my taillight? Why didn't you pull the frame? He comes out from the dealer. He walks to me, sir, Your Honor. He goes, if you ever come back here, I'm gonna break both of your legs.
Oh, really? Now we got a stress now being made.
Exactly, and that's why I came.
You
and I-
take, you, hang on. You take and you have a process server serve this. Okay? You don't go in there. If he's threatening you, I don't want to send you in there. You
I don't want to, I don't want to deal with it.
and tell Mr. Parker that if I find out he's threatening this gentleman again, I'm calling the police. Okay? You got it? God, who does he think he is?
Cause they
break
called the cops on me. And I have a
Who
reporter,
called the cops?
they did.
Feldman?
Yes, because I went to talk to Joe about my car, why didn't he do it right?
Well, Mr. Parker, he's gonna have a lot of answers to give. Okay?
Understood.
And if you tell me, better not contact this guy, this gentleman, between now and the court date.
I don't have no enemies.
It's fine,
No.
it's fine, it's fine. I don't like
It's
that.
official.
I don't like that threatening stuff. It's not gonna go on. Okay? If it goes on again, you call the police. I'm just telling.
He called it first and.
I don't care what he did.
Up here.
I don't care what he did.
And I'm not.
I can't believe if Feldman would tolerate an employee, if that happened, I'm not saying it happened, but if that happened, I can't believe Feldman would tolerate an employee talking to a customer like that or any other member of the public like that, if that happened. I'm not saying it did, but I'm not saying it did me. And if he did say that, you know what I'd have him doing? He'd be out the door in about 12 seconds. That's all I want to say about it. I'll see you guys on the 13th. Go down to the civil department. Thank you. All right, LVNV versus Essenmacher. 25-02703.
Sorry, Judge. Good morning. Attorney Ashley Notice Hartman on behalf of plaintiff.
Ma'am, your name?
Vicky Essenmacher.
Good morning.
Good
So,
morning.
counsel, what do you have to say? Did you guys talk?
No, Judge, we're back on our motion for summary disposition. I think this is the third hearing that we set for this, so we're ready to proceed.
Really?
Yes,
Do I
Judge,
have-
based on,
Do I have
Based
that? Hang on one second. Yeah, okay. Let me just double check. Now I see. Okay, defendant to file response to plaintiff's motion for summary disposition, and then I had a motion hearing, response to motion due by November 24th. I haven't received any response from you, right, Ms. Essenmacher?
Oh, yes, I sent, filed the affidavit you asked me to do the last time we spoke.
Judge, there was an email sent, which, I mean, isn't a proper form or, response, but if you accept it, you accept it. That's fine.
I had it, notarized like you asked me.
And that was from Tuesday, November 25th.
No, this was a, affidavit I got, like a week and a half ago. And I got an email that it was accepted through the courts.
Well, I mean, she's got a signed affidavit. I realize she's improper. She's saying she denies the debt, thinks there was fraud. How can I grant your motion? I don't think I can.
Well, you can, Judge, based on the evidence we've provided. We've provided every statement. I broke it down very thoroughly and I'm ready to go over it. It's not fraud. There are very specific things that point to the indication that it's not fraud. I've explained that in the motion. And again, if you want me to go through it verbatim,
I do.
I
I do. I
Okay.
really do.
Yeah.
I don't know why I didn't take a look at this, and that's my mistake. So go
That's
ahead.
okay. So on October 11th, 2021, the defendant opened a credit card with original creditor Credit One Bank. I attached all the statements that show that the defendant used the account to make numerous purchases and then also made numerous payments in the account throughout the life of the account. So it wasn't just one payment, it was multiple payments. that this defendant had 6 different credit card numbers, because as you see through the account statements, she would make a ton of purchases, dispute it as fraud, it would be determined invalid, she'd get a new card number in the interim. She'd use the card again, dispute it as fraud, it would be determined invalid, she'd get another credit card number. So this went on 6 times where she would use it, dispute it, and again, in the interim, making payments on the card. And then original creditor would say these disputes are not valid. And then a few things to point out. She used the credit card to make airline tickets, which when you purchase an airline ticket, they are in your name. You have to provide ID to get that ticket, to use that ticket. It's in her name. That's on all the statements. There's a rental car, which same theory. You have to provide your information, use your name, provide your name. So the whole idea that it's fraudulent, it's just untrue. I mean, you specifically have to provide these things to purchase these things, to use these things. And it's very counter-indicative of fraud when there's payments made throughout the life of the account. And as you also see, the disputes were addressed each time by original creditor and deemed invalid. And those charges that she disputed were put back on the account, and hence why the balance was accruing. So she wasn't paying off the balance. She was making, I think, minimal payments. So again, I walked through that.
Where was the airline ticket to?
Florida.
What airport?
That was, it's on the statement, Judge. Let me get to it.
Yeah, I don't have all the statements.
Yeah, so on 4/29 of 2022, Spirit Airlines, it was from DTE to South Florida. And then I believe there was
South Florida, meaning what airlines? I mean, what airport? You're talking about Fort Myers?
I don't know the to airport, but the from was DTW or DT, whatever our things are.
Did you go to Florida in April of 22, ma'am?
No, I did not. I actually disputed those charges for the airport and the car. I was actually, like I was telling you, mourning my husband's death when this happened. In October of 21, I was in the hospital on oxygen, and my husband died of COVID a few days later. I was also in the hospital, so there's no way I could have gotten a card. I tried to tell them I never even got a card at my home to use. I would take a lie detector test. I was taking care of my 11-year-old daughter. I couldn't even leave the home. My family was bringing me groceries for months. I was at home. I wasn't taking trips on oxygen, running around.
Judge, respectfully, this statement, the ticket in her name. And again, that's something that, you can't, and it says from Tampa, and
Jennifer,
then Tampa
do you
back to
have all
Detroit.
the statements attached somewhere down there?
Yes, Judge, I can look. I'm sure if they filed them with the motion, I have them.
I did.
I'm just telling you, Ms. Assenmacher, if I find out that you're lying under oath on this, I will go to the Wayne County Prosecutor's Office. I'm not suggesting you are, but I just want to be clear about that. If I find out that you were lying on a notarized document, that is what is going to happen. I promise you. I'm not threatening you. I'm telling you. It will happen.
And Judge, this is my argument as well. She disputed this card. It's clear by the statements as you go through them, and each dispute is deemed invalid and the amounts placed back on the card. So if original creditor deemed them invalid, I don't see why they would be valid now. In addition to that, okay, she submitted an affidavit. Okay, but I can also say the sky's purple and notarize it, and that doesn't make it true. I mean, she doesn't provide any documentation from then. She doesn't provide bank records that show she didn't make a payment. There's no police reports. I mean, everything we've provided and the facts and circumstances outstanding the documentation does not indicate this is fraudulent.
Did you ever make a police report, Ms. Assenmacher?
Yes, I did, and I sent them one like 5 times, and I gave one to.
Sent who one? What? 5 times?
I sent one to the lawyer, Mr. Johnson. He gave me.
Wait a minute, slow down. You sent what? You said you.
Report.
Now, did you make 5 police reports?
No, I just made one.
With what police department?
Trenton, where my items were stolen from the hospital. from my husband's dead body in Trenton, Beaumont at the time,
When was that police report filed?
in 22.
I don't have that, but again, it wasn't provided to original client who deemed these not fraud.
I even sent it to the creditor, and the only reason I made payments was because they threatened me and told me if I didn't, they would put it on my credit until they could get it situated. That's what they told me. You have to make payments. That's why I was making minimum payments.
She's telling me that you disputed charges 5 times. Did you do that?
I disputed the charges every time they would come back to me because I didn't understand why I was getting charged for something I never got. There was other credit cards I also had to dispute because people were putting cards in my husband's name and mine, because when he passed away, my ID, my social security card, and my insurance cards were in his wallet. I went to retrieve them when he passed.
Let me stop you. Let me stop you. Counsel, look, she's either up for an Academy Award or something, but I've got an affidavit here. She's improper. I have to find there's no genuine issue as to any material fact.
There's not.
It may very well be. If she's lying, I'm going to get to the bottom of it. I'm denying your motion for summary. We're going to trial on December 22nd at 10:30. Okay? So
Judge, would my witnesses be able to appear by Zoom? Because that is very short notice. And to be honest,
wait a minute. How long have you guys had that?
Well, I'm going to be very candid with you, Judge, which I'm sure, you see this all the time. I mean, based on our motion, I just don't even believe that there's a genuine issue or there's a genuine defense.
So listen.
I
I've
know,
been here 31 years. You're not going to be the first lawyer that, listen to me. You're not going to be the first lawyer that disagrees with me. Okay? You guys can all line up from here to Washington, D.C. It's okay. I'm giving her the benefit of the doubt because she's either an actress that deserves an Academy Award or she's, and that might very well be, but there's at least a fact issue. That's what I'm doing. How long have you guys had notice of the trial date?
Well, here's the thing, Judge. I'm not sure, to be honest, because we're kind of going through an attorney issue here. So it's been crazy. But here's a few other things to state for the record, to make my record, if you don't mind. We've been back and forth on this numerous times.
Counsel, to make a record on my denial of the motion for summary?
Well, yes, because I may file something in regard.
No, I'm not. No, I heard you. I know you've been back and forth. It's okay. I mean, I'm not going to let you do that. You can take it to the circuit court and they can send it back. I haven't been reversed in 25 years or so. And I might be wrong on this one, but you made your record. Now, if you really jammed up over this, I'd set the date on November 3. I don't mind setting another date. Where do your witnesses need to come from?
Oh, gosh. Let me see.
Ms. Essenmacher, I'm telling you, I will get to the bottom of this. If I find out that you're lying to me, you're going to have a massive problem.
I am not.
Okay.
They're coming from South Carolina.
I don't even know anyone from South Carolina.
What's that?
I said, I don't even know anyone from South Carolina.
No, she's talking about the witnesses. You don't have an objection to them appearing by Zoom, do you, Ms. Essenmacher?
No, I don't.
All right. The witnesses can appear by Zoom.
And then are we going to keep that 12/22 date?
I'll go ahead and move it.
Thanks.
What do you want to do, Jennifer? Can we do this sometime in the latter part of January?
Well, our last civil day in January, the 27th, we have that all-day trial for Concord.
No, give me another day. I mean, I don't care when I do these things. I could do it in an afternoon on a Tuesday, Wednesday, Monday.
Okay.
It doesn't matter to me.
Do you want to do the afternoon of the 20th? That's,
Yeah,
you've
I
got
might not-
probation and department reps that day.
I might not be here then.
Okay,
How old's this case?
let me look.
It's not that old. Let's do it the first, give me a date, the first week of February.
Okay, we can do the 3rd.
3rd is good.
You have department reps that day, so do you want to do it in the afternoon on the 3rd?
I'm usually done with those by about 11, so let's do
Okay.
it at 11. February
that works.
23rd, 26th at 11
February
a.m.
3rd. You said 23rd. Sorry, Judge.
I'm sorry, no, February 3rd at 26. If I misspoke, my apology. February 3rd of 26 at 11. Witnesses can appear by Zoom. You should be in person here, Ms. Assenmacher, and I want whoever's representing you, Ms.
I'll come. That's me.
Yeah, so you're gonna have to be in person here, okay?
Sure. Yeah, no problem.
We'll go from there. I can tell you that the M filing does not help any of this, but I'm sure lawyers like it, and at least this judge hates it. I'd rather have paper files. But
I'm that with you, Judge, so I understand.
that's what I'll do. Okay, thank you all. Have a good day. Merry Christmas, happy holidays. Good luck.
Thanks, Judge. You too.
All right. Muhammad Azim, 25B 730-199.
Judge, thank you, and good morning for those, good afternoon for the record. Raymond Attorney Mike Baldwin, P 65417 on behalf of the.
I need to take the signing on record first. Detective, your name?
Detective Claft, Brownstown Township Police Department.
Raise your right hand, solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, it is, Your Honor.
Okay, go
On
ahead.
December 14, 2025, at approximately 1:30 a.m., Officer Cormier was dispatched to 17148 Geranium Drive on a report of a domestic dispute. Our dispatch advised female caller, Miss Farad Azim, said her husband hit her and she needed to go to the hospital because her hand was possibly broken. Upon arrival, Officer Cormier made contact with our victim, Miss Azim, inside the residence, along with defendant Mohammed Azim and informational subject Alyssa Azim. Officer Cormier spoke with victim Azim, who said while her and her husband Mohammed were upstairs in the home, they had an argument. Ms. Azim indicated she was upset because Mohammed has been out late with their son Zayan, who is sick. Ms. Azim advised things escalated and Mohammed pushed her in the right shoulder arm area. He then proceeded to push open the bedroom door into her, injuring her arm and wrist. Ms. Azim stated Mohammed Azim did this on purpose and believed her arm wrist may be broken. Ms. Azim said she wants to press charges. Ms. Azim's right wrist appeared to be discolored and swollen. She was checked out by Brownstown Fire Department on scene, however, refused transport. While on scene, Officer Cormier spoke with Mohammed Azim, who said he and his wife, Ms. Azim, began arguing over their son, Zayam, who is sick. Mohammed Azim indicated that Ms. Zahim wanted him to leave the bedroom, at which time she attempted to close the bedroom door, hitting his arm. Mohammed Azim mentioned he then opened the bedroom door, which hit Ms. Azim, but Mohammed stated he did not know she was there. Mohammed advised there was nothing physical and that his son, Zain Azim, was in the bedroom during the incident. Suspect injuries. Officer Cormier did not observe any injuries, nor did Mohammed Azim complain of any injuries related to this incident. Mohammed Azim did get checked out by Brownstown Fire Department and said he wanted to go to the hospital because he was not feeling well. Officer Cormier spoke with Alyssa Azim, who is Mohammed and victim Azim's daughter. Alyssa said while she was at home, she heard her parents yelling at each other while they were inside their bedroom. Alyssa said she went over to see what was going on and could see her parents attempting to open and close their bedroom door on each other. Alyssa stated she did not see any physical altercation between her parents. Alyssa said she was able to separate her parents. Mr. Azim was arrested for domestic violence on scene. I do not show any prior criminal history relating to domestic violence or anything else.
There was never a diagnosis from the victim that she had a broken arm or shoulder or wrist or anything else, right?
Yes, Your Honor, I have no information indicating that she went to the hospital and was checked out or anything like that.
On your sworn testimony, I find the crime of domestic violence was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and warrant. Mr. Baldwin?
Thank you, Judge. Before the court is Mr. Muhammad Azim. He's 64 years of age. He's gainfully employed.
Wait 1 second. We need him in there, yeah.
Sorry, up there. 2-3 steps.
Your name, sir?
Muhammad Azim.
Your appearance again.
Thank you. For the record, Your Honor, arraignment attorney on behalf of Mr. Muhammad Azim. Judge, today is the date time set for arraignment. My client's 64 years of age.
He waives weight reading, stands mute.
He does, Judge. Thank you.
Okay.
He's currently employed as I think he's saying Clean Tech Incorporated, as a senior technician. They do have an 8-year-old biological child between them. He has a valid driver's license. He has a high school diploma with some college background.
Let me stop you a second. I'm sorry. Any objection to a PR bond, detective?
No, Your Honor. No contact maybe with the victim or.
Mr. Azim, I'm going to give you a $2,500 personal bond. You don't have to post any money, but I want to be clear about some things here. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You're not to have any contact with your wife. You are not going to have any contact with Farida Azim. You cannot write her, phone her, text her, email her, or communicate with her in any way. You cannot have any contact with prosecution witnesses except through your lawyer. You can't go back to 17148. You cannot go back there to 17148 Geranium in Brownstown. I will allow you one visit and one visit only to acquire your personal belongings accompanied by the police. So you have to make arrangements with them for you to go back there, and you can get your own personal belonging, but you can't go back there without them. You're also not to possess firearms. You're not to possess dangerous weapons. If you have any, you're to surrender those to the Brownstown police. Do you understand that fully and completely?
Yes, Your Honor.
Your court date's going to be January the 6th at 10:30 in the morning, January the 6th at 10:30 in the morning. Okay? Anything else, detective?
No, Your Honor. Thank you.
Are there any questions?
What kind of bond? He's asking what kind of bond it was. It was a
Personal bond. You don't have to post any money.
I explained that to him.
Okay, I get it. Okay.
It's that promise to come back or you forfeit that amount.
Yes.
I'm doing all these, the felonies here or what?
I'm ready to go. I have,
People against Blake, Maurice, Morrill the third, 25B 7279151 FY.
Mike Baldwin, arraignment attorney. Judge, today's the date time set for arraignment. For purposes of arraignment, my client stands mute and waives formal reading the general information.
Sir, your name?
Blake Maurice Morrow.
All right, good morning, Mr. Morrow, or afternoon, I suppose now. I'm going to go ahead and arraign you. Your lawyer indicates you stand mute. You have a charge of home invasion in the second degree, which is a 15-year felony and larceny in a building. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference will take place 1 week from tomorrow, which is the 23rd of December. And the preliminary exam will be December 30. Somebody go down here December 16th at 9:45 for the PCC. And then December 23rd for the exam. I'm arraigning a felon right now. Well, they must have just made a mistake, right? The 16th's tomorrow. I mean, prosecutor's office is still going to be here both those days, right? Okay. Thanks. Okay, so I'm going to do the 23rd at 10 o'clock. Preliminary exam will be the 30th. At 11 o'clock. All right, now we're going to address bond. What do you have to say?
Very briefly, Judge, my client's 20 years of age. He's going to be 21 in January of next year. He works at Anthony Pierce Concrete. He's a laborer. He's seasonal layoff at this time. He is taking care of his minor niece who lives with him. He is a resident of Monroe. He also resides with his girlfriend, the client's girlfriend, who has 2 minor children as well. His highest level of education is the 11th grade. He has no additional credentials. However, he is certified